Supreme Court Justice Franklin Mercer winced as Officer Daniel Rourke slammed him against his silver Benz, blood welting where the cuffs bit his wrists. "Uppity old black man in a luxury ride. Who'd you lift it from?" Rourke sneered, planting a knee into the 74-year-old judge's back. Bystanders filmed in shock as Mercer, still dressed from a keynote address, was dragged toward the cruiser, his Princeton cufflinks scraping pavement. He stayed unnervingly calm, declining to reveal who he was. Nobody realized that this routine stop would crack open a nationwide lattice of prejudice and graft, rattling America's legal foundations. Is justice blind, or does it see skin first? Before we dive in, drop where you're watching from in the comments. If equal protection under the law matters, regardless of race or status, hit like and subscribe. Tomorrow's special uncovers how racialized policing gets shielded at the highest levels of government. At 74, Justice Mercer had driven this route 1,000 times. Today, the familiar road felt different, heavy with memory, as he turned toward Milford. 19 months into his tenure as the court's newest member, he rarely carved time to visit his hometown, a place that tempered his view of fairness. This short detour after law school commencement felt necessary, a pilgrimage to the roots that shaped his convictions. As the Mercedes rolled down Maple, recollections surged. Segregated fountains at the square, the whites only placard at Danner's Diner, the courthouse bench where his father whispered, "Keep your eyes down, son. Survive first. Look how far and not far enough," Mercer murmured, adjusting his mirror. He hadn't noticed the cruiser tailing him for 10 minutes. Officer Rourke, recently elevated to chief at 36, spotted an out-of-state luxury sedan and felt a prickle of suspicion. He prided himself on knowing everyone in Milford who could afford such cars. This stranger didn't belong. Rourke shadowed him, hunting any pretext to initiate a stop. When Mercer signaled a lane change, Rourke pounced, lights blazing, siren punching the afternoon. Mercer saw blue in his mirror, pulse hitching. An old reflex education and accolades never erased. He pulled over, hands fixed high on the wheel. Breathing evenly, Mercer prepared as he had countless times. Rourke approached, the window hummed down. "Good morning, officer. Did I do something wrong?" The cop scanned the elderly black man in an expensive suit, the leather cabin, the watch gleaming on Mercer's wrist. His gaze hardened. "License and registration," he said, ignoring the question. Mercer narrated each movement, slow and deliberate. Registration from the glove box, then wallet. Rourke watched skeptically. Mercer handed documents over. The name, Franklin Mercer, drew a smirk. "You expect me to believe this is your car?" "Yes, officer. It's registered to me. Is there a problem?" Mercer's voice stayed level, heart drumming faster. Rourke compared license to driver, then back again. "This says D.C. What business in Milford?" "I grew up here," Mercer said, "visiting my old neighborhood." The radio crackled. Rourke ignored it. "This doesn't look right. Step out of the vehicle." Mercer recognized the thin line between lawful direction and unlawful threat and tried holding ground. "Officer, I don't understand. I've given proper ID. If I'm not detained for a specific violation, I'm not required to exit." Color climbed Rourke's cheeks. "Out now," he snapped, hand hovering at his holster. "I believe you're in a stolen vehicle." Mercer knew arguing would escalate. He unbuckled, moved slowly, and opened the door. Rourke spun him toward the hood, barked orders. Hands on the metal, legs apart. Traffic slowed. A woman across the street lifted her phone. "Is this necessary?" Mercer asked, humiliation burning. "You old black folks think you can ride fancy without questions," Rourke muttered, patting him down with needless force. "Who'd you steal it from? Your boss?" Mercer held still, face impassive despite the slur. "I've committed no crime. The car's mine, bought 3 years ago." "Shut up!" Rourke yanked Mercer's wrists and cuffed them too tight. Gasps rippled as the officer drove him down, kneecap grinding into his back. "He's elderly," someone yelled. "Mind your business," Rourke barked. "I know my job." Mercer's cheek kissed hot asphalt, the indignity etching itself alongside too many earlier injuries. But something had shifted. This time he had the stature to turn humiliation into change. Hauled upright and marched toward the cruiser, he decided not to reveal his identity. He wanted the unfiltered experience countless black men lived through. The holding cell in Milford PD smelled of bleach and old despair. Mercer sat on a steel bench, wrists throbbing from overtight cuffs. When Rourke booked him, Mercer declined an immediate call. "I'll wait," he said, which irked the chief. "Suit yourself, old man." Alone, Mercer observed. Scratched plexi, worn tiles, cameras blinking indifferent. After 30 minutes, a younger officer approached, glancing between clipboard and prisoner. "Sir, I need to process your paperwork," Officer Jamie Pierce murmured. "You look familiar. Have we met?" Mercer kept neutral. "I don't believe so." Recognition widened Pierce's eyes. "Are you Justice Mercer?" The judge met his gaze. "I prefer not to discuss identity." Pierce swallowed, peeking toward the bullpen. "Sir, if you are who I think, this is a serious mistake." "Please don't," Mercer said calmly. "I want to see how your system treats an anonymous black citizen." Pierce hesitated, caught between protocol and dawning dread. When Rourke swept in, voice sharp, "Pierce, why is booking slow?" "Chief, I think we—" "Don't get conned," Rourke cut in. "They'll say anything. This one claims a 100-grand Mercedes." Pierce tried again. "Sir, we should verify more thoroughly." "Looks like identity fraud to me," Rourke snapped. "Book him, resisting and obstruction, too." Mercer noted how quickly the junior officer folded under command. Outside, the arrest video began racing across social feeds. Judge Down trended, though most didn't realize the elderly black man was a sitting justice. At the court, clerks fretted when Mercer missed a late afternoon meeting. Calls went to voicemail. His phone sat in an evidence bag. After 5 hours, chest tightness bloomed. He'd twice been denied water and had missed his heart medication. Pierce returned, looking stricken. "Sir, please tell him who you are." Mercer shook his head. "I'm learning how your system treats an ordinary citizen." Pierce whispered, "He's building a case. Says you gave fake ID and were belligerent." "Were you present?" Mercer asked. "No, sir." "Then you have only his account." "There's video everywhere," Pierce added. "Good," Mercer said. "Truth travels." Rourke appeared at the bars, arms crossed. "Fancy fake ID didn't fool us. Plates tie to F. Mercer, D.C. But you're not him, are you?" "I am exactly who my identification says," the justice replied. "A Supreme Court justice, sure," Rourke scoffed. "You expect me to buy that coincidence?" "Not coincidence," Mercer answered. "You were schooled by a system teaching you to see less when the skin is mine." Rourke's stare hardened. "You'll regret this game." He told Pierce, "No calls. Let him sit." Meanwhile, Mercer's daughter, Helena Mercer, a formidable litigator, saw the video. Her blood iced as she recognized her father on the ground. She called the Supreme Court's security detail while speeding toward Milford, jaw clenched. The county sheriff phoned the station too, asking about the viral arrest. Rourke dismissed him. Routine identity fraud, and hung up. In the cell, Mercer's chest cinched tighter, familiar cardiac warnings. Without medication, risk rose. Still, he held to the experiment's purpose. Have you watched authority assume the worst based on appearance alone? Comment 1 if you've seen respect evaporate when someone doesn't fit the expected profile for their job or car. Like this video if dignity under the law should be universal. Subscribe for the continuing investigation into bias that reality keeps exposing. Helena hurtled down the interstate, legal training wrestling panic. Her father, among the nation's sharpest legal minds, sat in a small-town cell. Twice the desk sergeant rejected her calls. No visitors before processing. "He's 74 and needs heart medication," she insisted. "Ma'am, lots of folks claim to know him. We'll verify identity first." Helena ended the call and rang the Chief Justice's chambers. "Emergency," she told the assistant. "Justice Mercer has been wrongfully arrested in Milford. Please alert the chief immediately." Back at the station, Pierce processed Mercer's effects and found an official Supreme Court ID tucked discreetly behind the driver's license. His stomach dropped a floor. Pierce hurried to Lieutenant Sofia Rivera, bypassing Rourke. "Sir, you need to see this." Rivera examined the card, color drained. "That man is in cell 3. On confirmation, Rivera called Mayor Joanna Reynolds. She had barely stepped from a council meeting when her phone buzzed. The White House called next. An aide asking about Milford's mess. Reynolds promised action and raced to the station. Rourke drafted more charges when she stormed in with Rivera and a shaken Pierce. "Daniel, what in God's name? Do you know who you've arrested?" "A con with a fake federal ID," Rourke said. Reynolds thrust the badge. "That con is Justice Franklin Mercer of the United States Supreme Court." Rourke stared, then shook his head. "Fake? Why would a justice be alone in Milford?" "Because he grew up here," Reynolds snapped. "Release him immediately and pray he doesn't sue this department into oblivion." Rourke hesitated, defiant. "With respect, Mayor, if this is an elaborate scam—" "It isn't," Pierce interjected. "I recognized him. It's him." They hurried to the cell. Mercer slumped, breathing shallow, skin ashen. "He needs a doctor now," Reynolds ordered, kneeling. "Justice Mercer, can you hear me?" "My medication," he whispered. "Briefcase. In the car." "Call an ambulance," she barked. Allen, as medics rushed in, Rourke stood rigid. "Uncuff him," Reynolds demanded. Rourke complied, disbelief still simmering. "This makes no sense," Rourke muttered. "Why not identify himself?" Mercer, lifted to a stretcher, met his eye. "Because the law's protections shouldn't depend on my title." As medics wheeled him out, Helena arrived, fury and relief colliding. "Dad, what did they do?" She turned on Rourke. "Hours without medication, he could have died." "This department will face the biggest civil rights suit this state's seen," Helena warned. "False arrest, excessive force, denial of medical care, racial profiling. Shall I keep going?" The mayor stepped between them. "Ms. Mercer, Officer Rourke's actions don't reflect policy. He's on immediate leave pending investigation." "Too late," Helena said. "My father nearly died." News vans clustered outside. Chirons screamed, "Supreme Court justice arrested. Denied medication." The White House press secretary said the president was deeply concerned and had asked the attorney general to monitor. As Mercer was loaded into the ambulance, reporters shouted over sirens. Rourke watched, fear dawning as the magnitude of his choices came into focus. Back inside, Pierce told the mayor that Rourke carried a history of profiling complaints, 3 internal investigations in 2 years, all quietly buried. "He targets luxury cars with black drivers," Pierce said. "Everyone knows. Nobody says it." At the hospital, Mercer stabilized, finally given his meds. Security from the court converged. Helena anchored herself at his bedside. When they were alone, Mercer squeezed her hand. "This isn't about me, Helena." "They could have killed you," she said, eyes wet. "Do you understand?" He nodded. "They have killed others, with less standing, fewer lifelines. That's why I stayed anonymous. I needed to see the experience unvarnished." "So what now?" she asked softly. "Now," Mercer said, "we see how the machinery really works." He insisted on reviewing Helena's legal options, despite doctors' cautions. "We're filing federal civil rights claims, profiling, excessive force, deliberate indifference," she said, spreading documents. Mercer nodded. "And Rourke?" "Administrative leave with pay," Helena said, disgusted. "For now." Across town, Rourke posted bail after brief processing. His unexpected champion, the Valor Officers Alliance, VOA, a muscular group backing police in any storm. "We stand with Chief Rourke," declared spokesperson Thomas Greer at a quick press hit. Within hours, VOA secured high-profile attorney James Whitaker. Known for defending officers accused of misconduct, Whitaker launched an immediate counteroffensive in the court of opinion. Justice Mercer's record shows anti-police bias, Whitaker told reporters, grossly distorting a nuanced jurisprudence. Conservative outlets amplified. Had Mercer engineered the incident to advance reform? Soon, an edited arrest clip circulated, sanitized of slurs, framing Mercer's flinch during handcuffing as resistance to justify force. Helena's media team spotted the manipulation, warning, "They're seizing the narrative fast." Threats flooded Helena's office. Police recommended personal security. Hospital administrators moved Mercer to a restricted floor after a man pretending to be from the court tried accessing his room. Guards took post. Whitaker escalated, alleging Mercer's lifelong vendetta against police since the 1960s. Another smear. Meanwhile, Milford split into camps, rallies sprouting across the courthouse lawn. VOA's demonstration drew hundreds, signs reading "Back the Blue" and "Rourke did right." Mercer watched cable coverage in stoic silence. "Poker face," said Dr. Marisol Diaz, checking vitals. "But your blood pressure tells the truth, Justice Mercer. Breathe." Calm proved elusive when a fringe site published his medical records, privacy shredded, claiming he was unfit to serve. Helena's investigators uncovered Rourke's link to the Guardians of Heritage, GH, a white nationalist militia with multi-state chapters. Photos showed Rourke at a GH cookout 2 years back. He claimed it was just friends. Encrypted chats suggested GH had tracked Mercer since his appointment, viewing him as a threat to traditional order, a chilling escalation. That night, Mercer's childhood home, since landmarked, was vandalized, slurs scrawled, BLM hoax tagged, the porch torched before firefighters saved the structure. The message was unmistakable. This wasn't only about a traffic stop. It was open warfare over narrative and power. Have you noticed how quickly stories get reframed once institutions feel threatened? Comment 1 if you've watched racial incidents rebranded as misunderstandings under bright lights, like if you believe equal protection covers bench warmers and bench sitters alike. Subscribe to follow this investigation into how deep prejudice roots run in the justice system. Crucial question: when guardians of law face profiling, how blind is justice, truly? Against medical advice, Mercer was discharged, determined to keep health from overshadowing the larger fight. Outside, the media scrum resembled a presidential gaggle. Will you recuse from police cases? Did you withhold your identity on purpose? Was this racially motivated? Helena eased him into a waiting SUV, flanked by court security. No comments at this time. Privacy proved impossible. Paparazzi camped the hotel lobby. Staff leaked the room number. The phone rang incessantly until they cut the line. Meanwhile, Rourke became a conservative media staple. His exclusive with primetime host Trent Carlson cast him as a dutiful cop persecuted for protocols, language careful, posture aggrieved, a martyr offered to the algorithm. "I treated the stop like any other," Rourke told Carlson. "The driver was evasive, handed suspect ID, and refused standard procedure." Asked if he'd act differently, knowing Mercer's identity, Rourke intoned, "I respect the robe, but suspicion isn't about race. It's behavior." The interview surged support. VOA organized a mega rally outside headquarters. Thousands arrived. Online analysis revealed hashtag swarms, stand with Rourke, to protect our police, pumped by botnets. Helena's cybersecurity expert, Marcus Wynn, traced clusters to servers linked with extremist ecosystems, including GH. "Not a lone wolf," he said, "it's a system." Pierce, now transferred after threats, shared internal emails showing Rourke's phishing strategy: pull over black drivers in nice cars, search for anything. The president weighed in through the press secretary. The DOJ would review the incident as a potential civil rights violation. VOA fumed, launching a dossier project to paint Mercer as anti-police. Quotes cherry-picked, context stripped. After days of speculation, Mercer broke silence, granting an interview to Anderson Cooper, filmed in the guarded hotel suite. "I didn't identify myself immediately, Moscom. Mercer said, voice steady despite fatigue. Because I needed to experience what millions experience daily, to see how the system treats a black citizen without status. Deception? Cooper pressed. Mercer replied, no one must volunteer a resume to merit constitutional protections. The promise isn't for the prominent, it's for everyone. The interview set rating records, Mercer's controlled dignity outshining the frenzy. His account of sitting cuffed, denied medication, while officers disbelieved obvious identity, struck a nerve. In that cell, I wasn't a justice, he said. I was another black man presumed guilty or presumed lying because of my skin. The country listened, uneasily. The next day, Chief Justice Roland Menendez issued a statement. While respecting Mercer's personal experience, the court's integrity required impartiality. They requested Mercer recuse from upcoming police conduct cases to avoid appearance of bias. The disappointment that flitted across Mercer's face was brief but real. Helena urged a fight. Mercer shook his head. They're missing the point. This isn't about bias against police, he said. It's about recognizing bias already threaded through the system. The recusal request split the court. Two liberal justices offered quiet support. The conservative bloc stayed silent. Scholars argued whether lived discrimination warranted recusal. Responses broke along familiar political seams, as if jurisprudence were a team sport. Helena's team unearthed a larger pattern. VOA wasn't merely defending Rourke, it bankrolled campaigns undermining progressive jurists. Rourke was a convenient vessel for a broader agenda. Dad, Helena said, this isn't a stop, it's leverage against the court. The Milford County Courthouse swelled with lawyers, cameras, and demonstrators as the civil suit's first hearing approached. Judge Thomas Riker, 66, stern, reputedly deferential to law enforcement, took the bench in courtroom 3. Helena worried about impartiality, but lacked grounds to move for recusal. At the defense table, Rourke sat beside Whitaker, both crisp, unruffled. Mercer entered with Helena and counsel, steady despite lingering weakness. The gallery hushed instinctively. Riker warned, this court will address law, not the media carnival. Whitaker's opening painted Rourke as a trained professional, reacting to suspicious cues with no racial animus and no excessive force. Justice Mercer's failure to identify himself, he argued, created confusion any reasonable officer would manage similarly. Helena's counter framed specific policy breaches and constitutional violations with receipts. The evidence shows a pattern, she said. Rourke targeting black drivers of luxury vehicles, escalating a routine stop without cause, using racial slurs, denying necessary medication, ignoring proof of identity. During recess, Helena heard Riker and Whitaker were old law school classmates, linked through a conservative legal society never disclosed to the court. We'll gather more, she decided. Pierce testified next, describing Rourke's fishing expeditions and the refusal to verify Mercer's identity. Whitaker's cross was cutting. You were passed over for promotion 3 times under Chief Rourke. Retaliation? Pierce held the line. I'm here because Justice Mercer's treatment wasn't an anomaly. It matched a pattern I've seen for years. His words hung, heavy and credible. A court officer slipped Mercer a note. He wrote back, face unchanged. Helena paled reading it. Mercer's D.C. home was burglarized. His home office rifled. Documents for pending Supreme Court matters targeted. The FBI was notified, viewing it as a potential national security breach. Helena whispered, we should request a recess. Mercer shook his head. We continue. The FBI's preliminary take. This wasn't random. The theft seemed surgical, aimed at briefs involving qualified immunity. Implications mounted. Were Rourke's backers tied to broader efforts swaying jurisprudence? Whitaker called Rourke. The officer painted himself as seasoned, guided by instincts honed over 15 years. The driver felt evasive. The vehicle didn't match typical elderly locals. On cross, Helena was unflinching. You said he was evasive, yet body cam shows concise, compliant answers. Explain the discrepancy. Rourke shifted. Tone, body language. And your racial slurs Captured on bystander video, standard procedure too? Riker interjected. Counsel, stick to facts, not provocations. The language is on multiple recordings and evidence, Helena replied. The imbalance was glaring. Journalists traded looks as Riker sustained Whitaker's objections and swatted Helena's. Key evidence, Rourke's complaint history, was excluded. When Helena pushed back, Riker flirted with contempt warnings. Tension crackled. Then, a development. Sarah Martinez, the young woman who filmed the original video, arrived to testify with enhanced footage, capturing slurs clearly, an evidentiary thunderclap on approach. She never made the steps. An unmarked black SUV ran her car off the road en route. She escaped with minor injuries. Message received. Witnesses should stay quiet. Have you watched institutions close ranks to shield their own? Comment 1. If you've seen judges, police, and politicians operate two standards, one for insiders, one for everyone else. Like if you believe transparency and accountability should span street cops to Supreme Court justices, subscribe to keep following where this case leads. When those sworn to uphold justice circle wagons to obstruct it, what does that say about our legal bedrock? Is Riker's tilt personal or a lane in a larger protection plan? Martinez entered at last, arm in a sling, determination hardening her features. The full, unedited video played in court. Rourke's slurs audible, his force plainly excessive, most damning. These people need to learn their place, as he pressed Mercer down. Riker had no choice but to admit the video, reluctance telegraphing across his jawline. Rourke's face mottled. He hissed to Whitaker, then stood and barked across the well. This is a setup. You people will do anything to take down good cops. Officers restrained him before he added, You'll regret this, Justice Mercer. People are watching. Riker declared recess, threatening contempt, but his ruling still leaned defenseward afterward. Outside, Martinez found her windshield spray-painted GH with a crude threat. Officers shrugged, probably kids, despite the obvious tie to guardians of heritage. That evening, Helena met FBI agent Rebecca Torres in a plain coffee shop miles from Milford. GH isn't local, Torres said. They're a national network, members in law enforcement, judiciaries, political offices. They've been on our radar for years, Torres continued, but they compartmentalize. Leadership resists politicizing investigations. The file she slid across showed GH receiving funds via slaloming nonprofits linked to police unions and private donors, some connected to VOA. Communications hinted at coordinated influence campaigns, judicial appointments targeted, civil rights cases hemmed. The pattern felt less conspiracy than infrastructure. Stolen documents from Mercer's home turned up in the apartment of Michael Collins, a GH-aligned security contractor. The FBI raid recovered not only case materials, but surveillance plans tracking progressive judges and civil rights lawyers. One dossier mapped upcoming Supreme Court policing cases, complete with pressure strategies, media storms, witness intimidation, judge shopping, and narrative warfare. Mercer absorbed the implications, gaze steady despite the tremor in his hands. This eclipses Rourke or Milford, he told Helena. They're probing the seams of the judiciary itself. Two other justices surfaced in donor ledgers, VOA-funded seminars and honoraria. Not illegal, but troubling. The pattern smelled like influence laundering, subtle pressure masquerading as educational outreach. Then the counterpunch. Helena's phone glitched, passwords failing. A forensic scan flagged sophisticated intrusion. She was followed by unmarked sedans. Hotel staff reported strangers fishing for her schedule. They moved rooms twice under court security. In that swirl, Whitaker approached with a silky proposition. Mutual de-escalation, he called it, dangling a quiet settlement that smelled like a muzzle. Helena's eyes flashed. You want us gagged while your client's narrative calcifies? Whitaker's smile didn't crack. America's attention span is short. Let's avoid collateral damage. Mercer listened, then declined. Sunlight, he said, not silence. Whitaker's parting look was frost-edged, an unspoken promise that the coming phases would be uglier, louder, and much more personal. As hearings resumed, Riker tightened procedural screws, narrowing discovery and hemming Helena's exhibits. He called it judicial economy. Reporters called it bias with a bench. Meanwhile, GH chatter spiked. Encrypted channels celebrating pressure points activated. VOA fundraisers proliferated. Patriotic branding wrapping hard-edged messaging. Mercer wrote notes methodically, building a map of overlapping hands on hidden levers. Rourke's public posture hardened into crusader chic, the beleaguered chief defending order against elites. His supporters painted Mercer as an ivory tower meddler, sabotaging safety. Helena countered with affidavits from Milford's black drivers, patterns of pretext stops, invasive searches, zero contraband. Riker excluded most as cumulative. The pattern kept disappearing in his courtroom, despite being glaring everywhere else. In a hallway scrum, a local reporter asked Helena if she feared losing. "Courts are slow," she said, "but evidence ages well." Mercer added, "The law is meant to outlast frenzy." That night, Helena's inbox filled with doxing attempts, threats, and a fake leak alleging tax improprieties, quickly debunked, effectively sticky. The harassment wasn't random, it felt choreographed. GH sympathizers organized counter-witness affidavits claiming Mercer cursed and resisted, details contradicted by video. Bots amplified the claims until reputable outlets hesitated, wary of both sides' pitfalls. Agent Torres advised patience and documentation. "They overextend," she said. "Networks like this can't help bragging." Helena archived everything, building a parallel record she suspected would become the spine of accountability later. A whisper reached Helena. Riker had once attended a private seminar hosted by a VOA-linked nonprofit, travel and lodging covered, panel on community order. Not illegal, but material. She filed a narrowly tailored motion for disclosure, explicitly not accusing impropriety, only seeking transparency. Whitaker scoffed, "Conspiracy thinking." Riker, jaw tight, took it under advisement. Mercer returned to the Milford Grand under a thicker security bubble. He tried resting. Nightmares replayed asphalt heat and the thud of a knee in his back. In quiet moments, he rehearsed the oath: support and defend the Constitution, wondering how often that promise frayed in small rooms, where no cameras watched and discretion tasted like impunity. The next morning, Pierce slipped Helena a folder, internal memos where Rourke dismissed bias complaints as statistical illusions. A spreadsheet tracked productive stops, with a column for driver profile coded by race. Riker excluded it as improperly obtained. Outside, a retired chief told cameras, "We don't have a racism problem, we have a respect problem." Mercer watched, expression unreadable. The president's statement became formal. DOJ opened a civil rights investigation. Rourke's camp declared federal overreach. VOA announced a legal defense fund topping 7 figures in 48 hours. Helena's team filed an amended complaint, meticulously threading constitutional claims through the facts Riker couldn't easily wall off. Quietly, Torres confirmed a multi-state probe into GH infiltration patterns. Helena scheduled a town hall at the black church Mercer attended as a boy. Elders spoke about generations of traffic stops, searches, and tone tickets. A father described his teenage son learning the script: hands visible, voice level, don't argue, survive. Mercer listened, eyes closed, absorbing testimonies he already knew, but felt again in fresh, scalding detail. Rourke held a competing rally on the courthouse steps. Flags, drums, speeches about lawlessness. He pointed at Helena's event, out-of-town agitators. Cameras caught a heritage banner, GH's dog whistle iconography, fluttering at the edge. When asked, Rourke disavowed any extremist group, while welcoming all patriots. The plausible deniability was calibrated, practiced, and as thin as tracing paper. Anderson Cooper aired a follow-up. Experts broke down traffic stop data, showing sharp racial disparities unexplained by crime rates. A former conservative judge surprised viewers. Humility is conservative. Profiling isn't. Mercer, watching, felt something loosen in his chest, not relief exactly, but evidence that narrative warfare could be met with disciplined, empirically grounded resistance rather than raw outrage. Menendez's chambers floated a gentleman's agreement for Mercer to step back from police cases for a term. Helena frowned. "They're institutionalizing your silence." Mercer sighed. "They're insulating the court." He penned a private letter to colleagues. Recusal is personal, not institutional. He would follow statute and conscience, neither more nor less. It wasn't defiance, more a constitutional boundary drawn in ink. Riker finally ruled on discovery, limited expansion, grudgingly allowing body cam metadata and dispatch logs. Helena excavated call times, cross-referencing with Rourke's stops. Patterns sharpened. Rourke shadowed luxury cars after shift end, scanning plates on backroads he knew lacked cameras. A habit of hunting. The word itself mattered, not patrolling, hunting. Prosecutorial power, predation-shaped, camouflaged by policy language. A leak landed. Emails from a regional police union strategist coaching narrative shields, insist on split-second decisions, pivot to officer safety, question elite meddling. The template matched Rourke's media lines. Whitaker dismissed it as fabrications. Helena, careful, authenticated headers and timestamps. Riker refused to admit them yet, demanding foundational testimony. The union vowed to delay indefinitely. Sensing momentum, Whitaker filed an anti-slap style motion, painting Mercer's suit as a political cudgel to chill policing. The audacity stunned even seasoned court watchers. Helena's opposition brief sang, tight citations, meticulous facts, constitutional spine. She ended, "This case isn't speech, it's conduct. The Constitution regulates power, not hashtags." Riker set arguments for the following week, tension humming. Meanwhile, GH escalated outside the courtroom, flyers depicting Mercer as an imposter judge, digitally aged into grotesque caricature. A vandal etched a slur into the Milford landmark plaque. Volunteers stood night watch with the fire department. Mercer visited the site at dawn, hand on the cool brick, whispering a promise learned at his father's knee. Endure, then build. Torres called. The Collins raid yielded burner phones with cross-state contacts, some wearing badges. A spreadsheet mapped friendly jurisdictions. Another tab listed influence assets, local radio hosts, donors, sheriffs, and a sprinkling of judges. Nothing, smoking gun enough for mass arrests, but far beyond coincidence. "Infrastructure," Helena murmured. Mercer nodded. "A shadow bureaucracy of grievance and leverage." In court, Helena dismantled the anti-slap claim. "Public criticism isn't our cause of action. State power misused is," she said. "Qualified immunity protects reasonable mistakes, not fabricated suspicions or deliberate indifference to medical need." Whitaker countered, painting Mercer as provocateur. Riker's questions cut Helena more sharply. Still, he denied Whitaker's motion, narrowly. A modest, meaningful crack let daylight in. Rourke's deposition loomed. He arrived with counsel and a composure bordering on theatrical. Asked why he ignored the radio that day, he gave traffic noise. Metadata showed the volume lowered. "Safety," he said for cuff tightness. Medical notes documented skin abrasion and swelling consistent with excessive force. "Subject tensed," he offered. The choreography felt pre-written, defensive, brittle. Helena showed him a training bulletin. Elderly detainees, monitor circulation, check cuffs. He claimed he hadn't seen that version. Initials on the sign-off page matched his. He blinked, then blamed clerical error. When asked about the slur, he said the audio was deep-faked. Independent labs authenticated waveforms, microphonics, and room resonance, linking the voice to his body cam's onboard mic. That afternoon, Whitaker filed a motion to sanction Helena for ambush tactics. Riker scolded both sides, then declined sanctions. Outside, microphones clustered. Helena said, "We'll keep litigating in here, not out there." Whitaker smirked, fed red meat to cameras. Mercer took no questions, moving slowly, one hand on the rail, the other grazing the pocket where his pills lived. A whistleblower from the VOA-adjacent nonprofit surfaced, an events coordinator who'd tracked travel stipends for alignment seminars. She produced invoices naming Riker among attendees a decade ago. Helena didn't accuse bias. She filed a renewed, narrowly framed disclosure request. Riker, stone-faced, acknowledged the trip and claimed no memory of sponsors. He refused recusal, insisting impartiality. The room exhaled, unsatisfied. Helena pivoted. Fine. Facts, then. She subpoenaed the seminar's curriculum, which framed community order as hierarchy maintenance, warning against judicial sympathy drift. Not illegal, not neutral. The syllabus spoke a quiet ideology in bullet points. Riker allowed it for context, not as proof of bias. Jurors wouldn't hear it. This was a bench battle with public stakes. In Milford, two teenagers were pulled over, austere leaving Helena's town hall. Their mother filmed the stop, posting it with the caption, "Fishing again." The clip spread, echoing Mercer's ordeal. The mayor announced an independent review of stop data. The union threatened a blue flu. Patrol coverage dipped. Calls held. Real people sat waiting while narrative wars raged. That night, Mercer spoke softly to Helena. The danger isn't only rogue officers, it's systems that metabolize complaints into paperwork without consequence. She nodded. That's why they fear discovery. He smiled, tired but wry. Discovery is American. His chest tightened briefly. He breathed through it. We keep our posture, he said, not because we're calm, because we're committed. The next hearing focused on admitting complaint histories under a pattern and practice theory. Helena showed anonymized tables, then tethered them to Rourke's badge number. Whitaker called it trial by spreadsheet. Riker, wary, allowed a trimmed set tied to rule violations with similar fact patterns. Discretionary, but a significant shift. For once a door didn't just crack, it opened. Almost immediately, GH accounts frothed about witch hunts, naming the clerk who processed the exhibits. The clerk received threats and took leave. Riker condemned harassment from the bench. Voice clipped. Outside, Mercer sent a handwritten note wishing the clerk safety. He remembered being a young public servant, learning that justice often asks ordinary people to carry extraordinary weight. A local pastor convened a peace march. No slogans, just silence, and signs reading equal protection. The stillness unnerved those expecting chants. Cameras captured Mercer on a balcony, hand to heart. Rourke's supporters staged a rumbling counter-parade, ATVs and truck horns. The sound thudded against the silence like a dare. Milford held its breath between two incompatible hymns. Torres flagged a financial bridge, a community resilience foundation paying media consultants who seeded stories undermining civil rights plaintiffs. Its donor-advised funds looped through the same umbrella supporting VOA and, indirectly, GH fronts. The laundering was legalistic, not legal. Follow the verbs, Mercer told Helena. Who coordinates, instructs, compels? Money explained a lot. Verbs explained intent. Martinez returned to testify in person on chain of custody and authenticity. Whitaker tried impeaching her with insurance records from the crash, implying inconsistency about injuries. She answered cleanly, unflustered. The full tape, unedited, remained the anchor. Jurors wouldn't see it yet, but Riker had, and something in his cadence softened. Still formal, but edged less like a knife. Pierce's second round on the stand was quieter, firmer. He described reviewing SOPs after the arrest, realizing how many had been bent that afternoon, refusal to verify ID against digital databases, denial of requested water despite age and medical disclosure, cuffing beyond comfort checks. Whitaker pressed motive. Pierce answered duty. Sunlight, he said, echoing Mercer unknowingly. Helena prepared closing remarks for the preliminary phase. We ask only for a trial on facts the Constitution recognizes and the community can see. Whitaker countered with a warning about handcuffing the hands that protect us. Riker took it under advisement. Outside, clouds stacked over Milford like unfiled briefs, heavy with the kind of weather that breaks quietly, then all at once. That evening, Mercer's secure phone buzzed. Torres again. The Collins devices showed a planned narrative weekend. Synchronized op-eds, influencer talking points, and a leaked ethics complaint against Helena, alleging conflicts, laughable but headline-shaped. "They're scheduling outrage," Helena said. "They're industrializing it," Mercer replied. "But factories have footprints." He circled dates on a legal pad, strategy forming. On schedule, the ethics smear dropped. A friendly blog spun it as whispers. Larger outlets demurred. Helena filed a formal response anyway, short, surgical, disproving each claim with receipts. The blog moved on. The insinuation lingered by design. Mercer studied the tactic, not to win in court, but to exhaust. Attention, resources, breath. Riker finally ruled the case would proceed to trial on narrowed counts: unlawful stop, excessive force, deliberate indifference. Profiling claims would be tried with strict evidentiary guardrails. Both sides claimed partial victory. In the hallway, a woman pressed Mercer's hand, whispering, "For my son?" He nodded, absorbing the weight with the same practiced care he used for precedent. Whitaker pivoted to settlement again, money without admission. Helena asked for structural reforms, independent monitoring, and Rourke's decertification. "Absolutely not," Whitaker said, smile gone. "Then no deal." Mercer agreed. Remedies must outlive headlines. The mayor, watching budgets, floated a hybrid proposal with training upgrades and data transparency. The union vowed scorched earth if external monitors touched Milford. Inside chambers, Riker urged exploration of global resolution. Helena said reforms were non-negotiable. Whitaker called them political demands. Mercer spoke last, voice measured. "The point is not punishment, it's prevention." Riker leaned back, fingers steepled, and said nothing helpful. Outside, thunder finally broke. Rain needled the courthouse steps, washing chalk slogans into gray, temporary veins. Back at the hotel, Helena's team mapped witnesses and exhibits on whiteboards, weaving timelines, dispatch pings, GPS points. Mercer marked in green where discretion turned to domination. "Juries understand story," he said, "especially the parts policy language tries to sand smooth." He paused, hand at his sternum, then waved off concern. "I'm fine," he lied convincingly enough. Whitaker filed a motion to bifurcate, separate liability from damages to avoid prejudice. Helena resisted, arguing the harm illustrated the choices made. Riker split the difference procedurally, but left room for narrative threads to stay visible. It wasn't perfect. It was workable. Helena exhaled, then sharpened opening themes: dignity, discretion, and the long shadow of denial. Martinez's car was vandalized again, tires slashed, windshield spidered. A detective suggested parking in a garage, for now, advice that landed like abdication. Helena arranged temporary housing and a rental. Community members raised funds to replace the car. The small kindnesses braided something sturdier than hashtags. Mercer wrote Martinez a note: "You steadied the lens, we'll steady the law." Agent Torres secured subpoenas for the Community Resilience Foundation's consultants. Emails revealed bullet-pointed scripts: if plaintiff bars judge, frame as elitist power play, undermine daughter as ambitious, flood zone with local voices columns. One attachment listed payouts to influencers who'd echoed those lines verbatim. Banal corruption, exposed in Calibri, with polite salutations and invoice numbers. Helena couldn't admit most of it, yet. But she could ask witnesses about contacts, coordination, best practices memos. Whitaker's posture shifted. More objections, more heat. Rourke grew brittle on camera, lashing out at questions that previously bounced off. The performance veneer thinned. Mercer noticed the twitch at the corner of Rourke's eye, the tick of someone discovering their script has holes. At a late-night strategy huddle, Helena asked Mercer if he regretted staying anonymous during the stop. He considered the ceiling, then shook his head. "We don't test systems by announcing our rank at the door." He added almost to himself, "A republic doesn't survive on exceptions." The room fell quiet, the kind of silence that clarifies rather than empties. Morning came with a surprise. Mayor Reynolds publicly supported data transparency and an external auditor for traffic stops. The union blasted political grandstanding. A council vote was scheduled. Rourke posted a video under an American flag invoking local control. Comments flooded with identical phrasing, clearly coordinated. Milford's fault lines etched deeper, yet the shape of reform began to appear. Riker calendared the trial, rejecting one last defense delay. Outside, summer cicadas drilled the air. Helena tightened her outline, balancing law with lived truth. Mercer, in a quiet corner, reread dispatch logs, fingers tracing timestamps like Braille. He smiled at Helena. "However this lands," he said, "we've made the invisible legible." She nodded. "Now let's make it actionable." That afternoon, Torres delivered a final pretrial update. Additional GH communications tied the Collins crew to a court pressure channel, celebrating the burglary, proof of concept achieved. Prosecutors were building cases carefully. "Will it be enough?" Helena asked. "Eventually," Torres said. Mercer looked toward the courthouse dome. "Then eventually starts here," he murmured. With record, remedy, and relentless attention, 2 other justices appeared in VOA seminar photos from years back. Smiles, plaques, innocuous captions. While not illegal, the optics sharpened the stakes of every policing case ahead. Helena's phone buzzed. Trial logistics. Martinez confirmed. Mercer exhaled, shoulders squared. The story would pause here, not resolved, but rightly framed. The next chapter would unfold under oath, on the record. In the courthouse garage, Whitaker ambushed them. "This can all disappear," he murmured. "Justice Mercer drops the suit, releases a misunderstanding statement, and GH shuts down its campaign." Helena didn't blink. "We don't bargain with extortion." His smile thinned. "This isn't bargaining, Ms. Mercer. It's a courtesy. Your father won't survive what's next." Helena alerted the FBI, but the threat materialized anyway. That night, partisan outlets trumpeted an audio of Mercer plotting to rig Supreme Court rulings against police. The clip, clearly synthesized, ignited instant outrage. Forensic analysts debunked it within hours, yet the smear did its work. Doubt bloomed faster than corrections traveled. Chief Justice Menendez phoned. "Franklin, this has become untenable. The court's credibility is bleeding because of your crusade." "Not a crusade," Mercer replied evenly. "Justice." Nevertheless, a majority voted to request a leave of absence until resolution, for the institution's good. The line clicked dead, leaving Mercer staring at the wall, stunned by institutional self-preservation. He exhaled. "They're afraid," he told Helena. "Not of me, of what this case represents. If a sitting justice can successfully challenge misconduct, everyone can." Helena nodded, jaw set. "So what now? They're coming from every angle." Mercer's expression steadied, the same calm that carried him from Milford's segregated streets to the nation's highest bench. "We widen the circle," he said. "One lesson in 74 years. Truth has power only when enough shoulders carry it." Night rain needled the hotel windows. The court, his home for 19 months, had urged him aside. The system he'd championed felt weaponized against him. Even federal investigators seemed tentative, constrained, insufficiently willing. "Maybe we're losing," he murmured, a rare fracture of doubt. Helena looked up. "That doesn't sound like my father." He turned, a tired smile ghosting. "Even old fighters tire, sweetheart." A coded knock interrupted. After the challenge response, Professor Walter Matthews, 60 wire-rimmed encyclopedic on extremist networks, stepped in, leather briefcase heavy with receipts. "Thank you for coming," Mercer said, clasping his hand. "I know the risk." Matthews nodded. "When domestic extremists target a Supreme Court justice, silence isn't an option." He unpacked documents across the coffee table, tracing connections among VOA, GH, and allies embedded in law enforcement and courts, facets of one movement wearing different masks. "These aren't separate fiefdoms," Matthews said. "They're coordinated, believing some citizens deserve protection and others don't." He followed the money, police unions laundering funds through foundations to underwrite judges, and politicians hostile to accountability. Judge Riker has taken over 50 grand in honoraria via VOA-adjacent groups, attending their leadership retreats 5 consecutive years. Matthews's database showed Riker dismissing 80+% of excessive force suits pre-trial, reliably tilting toward officers. Meanwhile, Officer Pierce paid a price for candor. Car windows smashed, traitor, carved into paint. The complaint with photos drew shrugs. His new department, squeezed by whispers from Milford, began questioning his loyalty. Sarah Martinez faced parallel retaliation. Her hardware store job vanished for downsizing, while 2 new hires appeared that week. References curdled mysteriously at other shops. Mercer discreetly arranged financial lifelines for both. Quiet thanks for courage. The pressure campaign spread to Washington. 2 supportive senators suddenly met random audits. A former Mercer clerk's appellate nomination stalled without explanation. Rourke, too, felt the trap steel. After his courtroom outburst, VOA handlers coached him with a chill he couldn't shake. Overhearing strategy chatter, he realized his case was merely a vehicle. Judicial control and immunity preservation, the real destination. When he voiced unease, a VOA lawyer secretly recorded him. Leverage for discipline. Effectively blackmailed, he tiptoed. Helena gambled, approaching him at a diner. "Officer Rourke, we should talk." He stiffened. "I'm not supposed—" "Your attorneys don't work for you," she cut in. "They work for VOA, and you're expendable." His eyes dropped. "What do you want?" "The truth. GH, VOA, who's pulling strings?" He slid a card, trembling. Detective Martin Walker, State Police. A handwritten note. Evidence. Lockbox. 447. First National. A seam opened. The larger breakthrough came from Mercer's docket review. Next month's Daniels versus Chicago Police Department could narrow qualified immunity for officers acting with malice. A ruling for the plaintiff would pierce decades of near absolute protection. This is the target, Mercer realized. Not my suit. Daniels. VOA's internal ledgers, routed to Helena through FBI contacts, showed massive mobilization around Daniels. Unions nationwide had filled a special fund to safeguard officer protections, legalese for preserving blanket immunity. The timing of the smears clicked into place with unnerving precision and purpose. Mercer met quietly with Senator Caroline Huang, Judiciary Chair probing extremist seepage into law enforcement. "We've mapped this network for a year," she said. GH, VOA, half a dozen allied outfits, shielding officers from liability while mainstreaming white nationalist currents into justice systems. Why no progress? Politics? Union pressure? No one wants anti-police branding in an election cycle. Rourke's lockbox yielded a USB internal VOA traffic about Operation Gavel, a campaign to influence the court. Admissibility would be thorny, chain of custody cracks and acquisition issues, but the content was explosive. Then Rourke's cruiser turned up abandoned on a county road, blood on the driver's seat, service weapon missing. Flight, locals suggested immediately. Helena's sources feared darker math. Liabilities get eliminated. Have you seen whistleblowers punished harder than wrongdoers? Comment 1. If Officer Pierce and Sarah Martinez losing livelihoods for telling the truth unsettles you, like this video. Subscribe to follow how power manipulates courts from the shadows and how accountability can still pry open locked doors. Thunder rolled as Mercer faced a thicket of cameras outside the courthouse. "For weeks, I've moved through proper channels," he began, voice steady, despite strain. "Today I address the American people directly. This was never about a traffic stop. It's about silencing a Supreme Court voice before a landmark accountability decision." VOA counter-programmed instantly, blasting breaking banners, Mercer under federal investigation for judicial corruption, pure fabrication suggesting suspicious payments from civil rights groups. Networks cut into his presser with the smear, seeding confusion exactly as designed. Meanwhile, miles away, a farmer found Rourke battered in a ditch, barely alive, admitted under a false name. Helena posted protection at the rural hospital, convinced he now held keys to the network. The USB's encrypted folder contained video, a VOA strategy session, openly plotting to neutralize Mercer before Daniels. Whitaker's line stung. If we can't control the court's makeup, we'll control credibility. No one trusts Mercer when we're done. The recording identified Riker as reliable and flagged his courtroom for Mercer's suit, case assignment shopping disguised as happenstance. At FBI headquarters, Director Samuel Harrington had hesitated, wary of politicization. That ended when Agent Torres tied GH cells to active domestic terror cases. Harrington finally greenlit a full probe, resources unleashed at scale. Matthews mapped financial conduits from GH to media platforms driving anti-Mercer narratives. Classic influence op, he said. They're manufacturing an alternate reality where Mercer's corrupt and Rourke's a martyr. From Washington, Mercer's older daughter, Jessica, a dogged investigative reporter, surfaced another piece, staffers leaking that reform-friendly lawmakers faced engineered pressure. Primary challengers appeared from nowhere. Audits sprouted like weeds. Local misinformation campaigns swarmed. Bipartisan, relentless. Mercer pressed Harrington privately. If the Bureau won't act, I'll memorialize these facts in opinions. The constitutional crisis implicit in that threat moved mountains. Harrington committed the Bureau fully. The enlarged investigation began paying dividends immediately. Intercepts showed GH infiltration in 27 state and local departments, with internal affairs placements shielding members. The long game undermined civil rights enforcement and enshrined proactive policing, a euphemism for profiling and aggressive tactics. Stabilized briefly, Rourke whispered to Helena, "They said they own me. No one would believe me if I flipped." Security tightened after an impersonator probed his floor. Riker's entanglements deepened. Subpoenaed records traced more than $200,000 in consulting from foundations controlled by VOA brass. He'd sat in closed-door sessions advising unions on judge selection strategies. He refused recusal, but the Judicial Ethics Committee opened a file. The Bureau moved. Simultaneous warrants at VOA offices and GH leaders' homes nationwide. The hall mapped a years-long conspiracy kneecapping civil rights enforcement and judicial independence. Whitaker vanished the night before questioning. Accounts emptied. Office abandoned. Border alerts flashed. He was smoke. Outside courthouses, VOA rallies thickened. Some openly armed. Threats shouted at Mercer's supporters. Counter-protesters surged too. The guard stabilized streets that hummed with peril. Martinez, still healing, received FBI protection after turning over footage from other Rourke stops, pattern evidence corroborated by 5 new victims. Pressure peaked. Menendez summoned Mercer to Washington for an extraordinary conference. "This exceeds a traffic stop," the chief said. "The court's integrity is at stake." Mercer returned under presidential-style security. Encampments flanked the marble steps. Stand with Rourke on one lawn, no one above the law on the other. Inside, the hushed temple vibrated with strain. In conference, 8 colleagues waited. "Elijah," Menendez began, "this now threatens the court's functioning." Justice Harrington, the rightmost vote, leaned in. "You must recuse from Daniels. Your objectivity's compromised." "On the contrary," Mercer said, "experience informs. It doesn't corrupt." Justice Catherine Chen frowned. "Appearance matters, too. Fair or not, your lawsuit looks like bias." Mercer met their eyes. "Would you ask a woman to recuse from gender cases because she's experienced sexism? Or Justice Mendoza from immigration because of family history? Context isn't bias." Debate sharpened. Conservatives called Mercer's participation untenable. Liberals warned that weaponized harassment would set a blueprint to sideline justices from consequential cases. Menendez floated a compromise, postpone Mercer's suit until after Daniels. Mercer declined. "That rewards obstruction. It says power can evade accountability by manufacturing chaos." News of the clash leaked immediately. Outside, GH staged an armed show of force. The guard held the line. Helena uncovered encrypted chatter about violence on Daniel's argument day. The Last Stand. Security ballooned. Snipers on rooftops. Vehicles screened. Perimeters extended. A note from the White House urged consideration of options to lower tensions. Polite code for step aside. Mercer burned midnight oil, drafting a discussion memo for colleagues, methodically deconstructing absolute immunity. His proposed standard: preserve protections for good faith mistakes, remove immunity for malicious or reckless violations. The draft rippled through chambers. Justice Anthony Fitzgerald requested a private sit down, eyebrow arched, curiosity overriding reflex. Your analysis is stronger than I expected, Fitzgerald admitted. I worry about practical effects. Mercer pressed gently. Discretion is essential. Impunity isn't. Balance is possible. Hours passed, questions deepening. When Fitzgerald left, Mercer felt the first real glimmer. Maybe experience, properly framed, could open minds rather than calcify positions hardened by tribe. Hope met resistance. Justice Bernard Morris circulated a scathing memo alleging Mercer let grievance eclipse law, warning reforms would unleash frivolous suits that paralyze policing. Then Helena called, voice tight. Leaked emails showed Morris receiving talking points from VOA about immunity, improper influence, if not outright ethics violations. Do we expose this? She asked. Mercer weighed institutional trust against sunlight. Before he decided, the FBI arrived with grimmer news: a credible assassination plot targeting Daniels Day, exploiting court security procedures, insider knowledge implied. Reduce appearances, agents urged, until we neutralize the threat. Mercer sat with the risk. The easy path preserved safety and harmony. The harder honored duty. Just before midnight, he chose and began to write. Daniels Day dawned under a fortress sky, barricades stretching blocks, tactical teams posted, counter-snipers scanning parapets. Mercer's motorcade used decoy vehicles. Inside, additional screenings slowed entry. In the robing room, handshakes were tighter, words fewer. Morris avoided Mercer's glance. Others offered clipped encouragement. Menendez pulled Mercer aside. Are you sure? The day threats dictate our work is the day the judiciary ends, Mercer said, smoothing his robe. Breaking news flashed. Rourke was awake and talking to federal prosecutors. The marshal's cry followed. Oyez! The courtroom rose as 9 justices took the bench, gravity palpably heavier than marble. Mercer's older daughter, Jessica, a relentless investigative reporter in D.C., picked up another thread. Hill staffers whispered about unusual pressure campaigns targeting lawmakers who backed accountability bills. Those members suddenly faced surprise primary challengers, random audits, and district-scale misinformation swarms. It wasn't ideological. Both parties' reformers found themselves methodically punished. Mercer leveraged position and principle in a blunt meeting with Director Harrington. If the Bureau won't move, he warned, I'll memorialize this coordination in opinions. The constitutional collision implied was unmistakable. Harrington relented, committing full resources. Almost immediately, the widened probe surfaced hard data where hunches had lived: names, flows, instructions, channels. Intercepts revealed GH members seated inside 27 departments, strategically posted in internal affairs units to blunt complaints. Long-term agendas sought to erode civil rights enforcement and normalize proactive tactics. Profiling by another name. Stabilized, Rourke briefly whispered to Helena, They say they own me. An impersonator tested his hospital floor. Guards doubled overnight. Financial subpoenas mapped Riker's deeper ties. Over $200,000 in consulting routed through donor vehicles helmed by VOA leadership. He'd also joined private sessions advising unions how to steer cases toward favorable benches. He refused recusal, yet the Judicial Ethics Committee opened a formal investigation. The facade showed widening hairline cracks. The FBI moved in force, parallel warrants for VOA offices and GH leaders' residences. Evidence painted a years-long conspiracy undermining civil rights enforcement and judicial independence via intimidation, narrative ops, and judge shopping. Whitaker vanished the night before questioning. Accounts drained. Office abandoned. Border alerts flashed. Streets outside courthouses thickened with armed rallies. Guardsmen established uneasy buffers. Martinez, still sore and defiant, turned over footage of additional Rourke stops, consistent pretext patterns corroborated by 5 new complainants. She received bureau protection. Pressure peaked. Chief Justice Menendez summoned Mercer to an extraordinary conference. This now imperils the court itself, he said. Mercer returned under a motorcade thickened like armor, helicopters drumming overhead. Outside the marble steps, encampments hardened. Stand with Rourke banners. No one above the law placards. Inside corridors hummed. In conference, Menendez opened soberly. Rightward stalwart Justice Harrington pressed, "Recuse from Daniels. Objectivity compromised." Mercer replied, "Experience informs judgment, it doesn't corrupt it." Justice Chen grimaced, "Appearance matters too. Perception can wound legitimacy." Mercer held their gaze. Would you ask a woman jurist to leave gender cases because she endured sexism? Or Justice Mendoza to abandon immigration matters for a family history? Context is not bias. Context is comprehension. Leans hardened. Menendez floated delay, paused the personal suit until after Daniels. Mercer declined. That rewards obstruction. The clash leaked instantly. Outside, GH announced an assembly. Rifles and slogans braided. Guard lines held. Helena flagged encrypted chatter planning violence on Daniels Day. Last stand. Security swelled. Rooftop counter snipers. Hardened perimeters. Vehicle sweeps. Canine patrols. A White House note urged options to reduce tensions. Polite pressure urging Mercer to step aside. Mercer wrote deep into night, circulating a discussion draft that dismantled near absolute immunity. His proposed standard balanced discretion with accountability, protect good faith mistakes, remove shields for malicious or reckless violations. The memo landed like a tuning fork. Justice Anthony Fitzgerald, often reliably conservative, asked for a private, open-minded conversation. Your analysis is stronger than anticipated, Fitzgerald admitted, brow furrowed. Practical consequences? Mercer pressed gently. Discretion is essential. Impunity isn't. We can distinguish error from abuse. Hours passed, questions sharpening. Fitzgerald left contemplative. Mercer glimpsed possibility. Experience framed in law might move a colleague beyond reflex and into rigor. Resistance arrived on schedule. Justice Bernard Morris circulated a blistering memorandum accusing Mercer of grievance-driven jurisprudence, predicting floods of frivolous suits paralyzing officers. Then Helena's call. Leaked emails showed Morris receiving immunity talking points from VOA. Do we expose this? She asked. The choice pitted institutional cohesion against disinfecting sunlight. Before Mercer decided, agents arrived. Credible assassination plot, targeting Daniels Day, exploiting court procedures, insider knowledge implied. Reduce public appearances, they urged. Mercer contemplated duty versus safety, harmony versus honesty. Easiest was retreat, harder honored oath. Near midnight, he chose the harder road, returned to drafting, and steadied his hands. Argument day dawned like a fortress. Barricades for blocks, tactical teams at intervals, counter snipers glinting. A decoy-laced motorcade threaded cleared streets. Inside extra screening throttled entry, but tightened control. In the robing room, greetings were taught. Menendez murmured, "Are you certain?" Mercer, "If threats govern us, the judiciary is finished." Breaking news cut the room's hush. Rourke regained consciousness, giving statements to federal prosecutors. The marshal's ritual call followed. The courtroom rose. Counsel for Daniels, family of a black teenager killed in a botched raid, argued narrowly. Immunity must not shield officers acting with malice or reckless disregard for rights already clearly established. Conservatives probed litigation burdens. Liberals pressed constitutional accountability. Mercer listened long, then asked neutrally, how do we preserve necessary discretion while ensuring citizens aren't stripped of remedies for intentional or reckless violations? Counsel proposed a calibrated standard, protect reasonable mistakes, pierce immunity for conduct beyond negligence into willful or recklessly indifferent territory. The city's lawyer leaned hard on split-second decisions and chilling effects. Justice Morris hammered that theme. Mercer reframed, "The Constitution guarantees rights, not administrative efficiency. Shouldn't the question be whether broad immunity, as applied, degrades those guarantees?" A ripple passed. Fitzgerald followed, building on Mercer's premise, hinting the draft's fingerprints on his thinking. Security entered quietly. The marshal delivered a note. Menendez announced a recess. In conference, they learned an explosive device had been intercepted at a service entrance. A GH adherent, disguised as maintenance, was arrested with a weapon. Evacuation protocols kicked in. Helena squeezed Mercer's hand. "They'll use anything to halt this." From his hospital bed, Rourke confirmed Operation Gavel, intimidation plus litigation, choreography targeting court outcomes. He implicated VOA leadership, Whitaker, and senior police officials. Most damning, Riker's explicit promise to handle Mercer's suit in exchange for support toward a federal nomination. Proceedings resumed hours later in a secure alternate courtroom. Atmosphere changed. The attempt clarified stakes. Even skeptics looked rattled. Arguments resumed with gravity sharpened. Mercer spoke softly but unmistakably. "Power requires constraint. When we place official acts beyond review, we license abuse." Fitzgerald nodded openly. Morris, unusually quiet, listened. The room felt less theoretical, closer to the constitutional bone than anyone preferred. In conference, initial votes were canvassed informally. Menendez leaned toward preserving immunity with tweaks. Mercer spoke of duty and remedy, not grievance. "We faced a threat to our function today. Citizens face threats too, from state actors. Our doctrine should not convert harmed people into rightless ones." Silence followed, thoughtful rather than dismissive. Mercer sketched the standard: retain immunity for good faith errors, strip it from knowing or reckless constitutional violations. Fitzgerald broke tradition by signaling alignment. "Persuasive," he said, telegraphing a possible 5-vote coalition. Momentum shifted. Then another jolt. Investigators identified a Supreme Court clerk funneling schedules and procedures to VOA, a breach explaining uncanny foreknowledge. Weeks ticked. 3 months after argument, the court released Daniels. A 5-4 majority reshaped qualified immunity, adopting what analysts dubbed the Mercer standard, protecting discretion while denying cover for malicious or reckless rights violations. Fitzgerald's concurrence traced his evolving view, crediting real-world effects on communities. The ruling triggered national training overhauls and policy rewrites. In Milford Square, a reconciliation ceremony unfolded. Rourke pleaded guilty to civil rights violations, trading cooperation for leniency and safety. He apologized publicly. "I was wrong. About you. About what I assumed when I saw you." A 5-year sentence shrank for substantial assistance and enduring attempts on his life by former allies seeking permanent silence. VOA's architecture buckled under indictments. 17 leaders charged with conspiracy, witness tampering, obstruction. Ledgers revealed millions in undisclosed influence funds aimed at shaping judging and smothering critics. Months later, Whitaker was caught in Costa Rica under an alias. Greatest extradited on conspiracy and intimidation counts. His seized files diagrammed media manipulation in misconduct cases nationwide. Riker resigned ahead of formal removal after investigators uncovered ex parte habits and money trails. Ethics proceedings became criminal referrals. Officer Pierce received the department's new Integrity and Service Award, then took command of a community relations unit designed to rebuild trust block by block. Sarah Martinez earned a full journalism scholarship from Mercer's newly established foundation. Her crash attackers, 2 GH members, were charged. The FBI's probe widened. GH-affiliated officers flagged in 73 departments. It became the largest police corruption review in modern history. Cases reopened coast to coast. The clerk who leaked to VOA had once worked for Justice Morris. Though evidence spared him direct liability, the association dented his standing. Most surprising was Fitzgerald's transformation. Collaboration on Daniels loosened ideological cement. He began crossing lines more often, baffling predictors. Sometimes, he confided to Mercer, we need a shock to re-examine doctrine's human footprint. In Milford, the Johnson, renamed Mercer, Center for Constitutional Policing opened, funded by Mercer's settlement redirected from damages into training and research. What happened to me was never one stop or one officer, Mercer told the crowd. It's about systems that shield misconduct and doctrines that place actions beyond reach. He nodded to Rourke, now helping train cadets as restitution. Transformation is repentance plus practice, Mercer said. Justice aims at restoration, rights, dignity, trust, not vengeance. The ripple effects reached classrooms and roll calls nationwide. Departments integrated Milford's lessons into bias and constitutional training. Most consequentially, Daniels created a litigation pathway previously barricaded. Legitimate claims advanced while frivolous suits still fell away. Sunshine and standards moved together. Neither sufficed alone, both necessary for a culture shift inside uniforms and courtrooms. The Supreme Court recalibrated too. Attempts to sway chambers triggered tougher ethics disclosures and clearer guardrails. Having felt vulnerability firsthand, justices recommitted to institutional independence. Morris, chastened by his clerk's betrayal and public scrutiny, proved more receptive in conference. Unexpected consensus forming in places that once seemed permanently factionalized. As the ceremony waned, Mercer noticed a young black officer patiently guiding an elderly white woman through the crowd. Conversation easy, smiles unforced. Small, ordinary grace. He thought of the long arc he'd quoted so often, and how it never bends unaided. It requires hands, policies, courage, and stubborn, hopeful attention. His years had taught him the arc doesn't move by nature. People move it, sometimes inches, sometimes miles, against friction that feels endless until it budges. In the town where he'd once sipped from segregated fountains, he stood honored as both justice and catalyst. For a breath, belief felt less fragile and more earned. Mercer's journey spotlighted how racial bias seeps even into sanctuaries we revere. Status, titles, accolades, none immunize a black man from suspicion. More unsettling, systems built to protect power mobilize quickly against challengers, yet the story also traced ways forward. Pierce and Martinez's courage, Rourke and Fitzgerald's change, doctrine reshaped by lived understanding. Most pivotal was the decision to set aside privilege in that moment by the roadside, to experience unbuffered what countless citizens endure. That empathy, translated into doctrine, became policy with teeth. True justice needs impartial rules and decision makers who grasp how those rules land on every kind of life they govern. Has this shifted how you see the intersection of race, power, and law? Comment whether authority truly shields people of color, or only sometimes, and never fully. Have you witnessed appearances overriding character and credentials? If Mercer had flashed his title, would accountability have followed? Like if you want leaders who know lived realities, subscribe for more reporting on how systems change when people refuse resignation. Share this with someone who doubts how privilege works. Sometimes its absence teaches best. Thanks for staying with hard truths. Progress isn't pretending bias is gone. Progress is confronting it, then building structures that deliver at last equal protection under law. As spotlights dimmed, church bells tolled across Milford, mixing with cicadas and distant sirens. Ordinary sounds in an ordinary town, now improbably central to a constitutional rebalancing. Mercer closed his eyes, hearing forebears in the hush between chimes. The work stretched ahead, but the path at last was visible, walkable, shared. Late that night, Helena updated the center's syllabus: scenario-based de-escalation, constitutional first aid, stop data transparency, community auditors with real authority. We'll teach posture, she said, firm and humble. Mercer nodded. Make remedy muscle memory. Outside rain returned, quiet but steady, needling through summer heat, washing chalked slogans into silver threads down Main Street. Jessica filed her long-form piece, tracing money, messages, and the day the court nearly bowed to fear. She closed with Fitzgerald's line about discomfort as teacher, then added her own, "Institutions learn when people insist they do." The story ran above the fold. 1,000 precincts printed portions for roll call discussion. Pierce addressed new recruits. Integrity costs. Pay it anyway. He held up his award, then set it aside. This matters less than a stranger's trust. Martinez, guest lecturing, explained chain of custody and courage. Film the whole scene. Keep originals off the cloud. And remember, truth needs guardians the way people need shelter. Rourke, under supervision, taught cuff checks and cardiac clues in elders, admitting where he failed. Some recruits bristled, more leaned in. Accountability isn't anti-police, he said. It's how policing survives. In the back row, a veteran officer wiped at his eyes, remembering a stop he wished he'd handled differently, vowing better. At the court, Menendez announced enhanced ethics protocols, outside briefings logged, travel funded transparently, staff clearances tightened. Morris supported the measures publicly, surprising watchers. Mercer said little, kept working. He understood durability lives in procedures more than pronouncements, in dull paperwork that outlasts tempers, embedding principles until they feel inevitable. State houses debated Daniel's implementation. Some dug trenches, others embraced change. Insurance carriers quietly began pricing departments on training, oversight, and claims histories, market incentives, bending behavior where rhetoric had sputtered. Plaintiffs' bars recalibrated too. Fewer scattershot claims, more focused filings. The sky didn't fall. It cleared enough for sightlines to improve. In Milford, the landmark plaque was replaced, now including the date Mercer was detained and the day Daniels reshaped immunity. The dedication drew crowds. A children's choir sang "America the Beautiful," verses too often skipped. Mercer smiled at the line about brotherhood, thinking sisterhood, neighborhood, and the stubborn dignity of belonging. A grandmother squeezed Helena's hand. "My boy got stopped last spring. He came home shaking. I want him trained by people from your center." Helena promised scholarships. Mercer watched promises multiply into logistics, budgets, schedules, instructors, and felt relief. Hope is lighter when handed off, distributed across many backs, moving in cadence. Fitzgerald visited quietly, touring classrooms and observation rooms. "Doctrine is bones," he said to Mercer in the hallway. "Practice is muscle." Mercer chuckled. "And conscience is breath." They parted with a handshake, warmer than tradition required, proof that disagreements, earnestly tended, can become scaffolding rather than walls inside constitutional architecture. Back in chambers, Mercer drafted another opinion, narrow, careful, attentive to record and consequence. He found himself pausing more often to consider operational realities without surrendering rights. Lived experience hadn't made him partial. It had made him precise. He wrote, struck, rewrote, until the reasoning felt as balanced as a well-tuned scale. 3 months after Daniels, the square hosted a second gathering. Less spectacle, more work. Vendors hawked coffee beside booths, demonstrating de-escalation techniques. Teen volunteers fitted body cam mock-ups and explained retention policies. A retiree marveled, "Never thought I'd see cops and kids practicing together." Someone answered, "That's the point. Practice together before it matters." Rourke's sentencing included a statement. "I harmed people I was sworn to protect. I'll spend the rest of my life trying to repair." He started a restitution fund for defendants wrongfully charged from his stops. Pierce contributed first paycheck over time. Martinez matched with scholarship stipends. Circles that once tightened now overlapped, tenuous but real. Federal cases against VOA leaders advanced, plea deals stacked, revealing more conduits. A handful chose trial, insisting on righteousness. Juries disagreed. Judges cited Daniels in sentencing memos, linking deterrence to dignity. The Bureau's report detailed infiltration tactics and offered model policies, dry pages that, if followed, promised fewer headlines and quieter, safer nights. National media moved on, attention is fickle. But local outlets kept score. Fewer complaints, faster discipline, more transparent dashboards. Not perfect, better. Better mattered. Mercer urged patience without complacency. Progress hates autopilot, he told a graduating class at the center. Steer it daily. Applause rose like weather, unflashy, encompassing, promising rain. Helena compiled a casebook from Milford, body cam metadata, dispatch logs, deposition excerpts, policy revisions, teaching materials with teeth. Law schools adopted it. One dean wrote Mercer, "Students engage when doctrine meets streetlight glare." Mercer smiled, hearing his father. Learn the rules, then watch where they're used to hide harm. Jessica's follow-up examined state reforms sparked by Daniels. Some legislatures codified the new standard. Others tried end runs that courts swatted down. She profiled families whose suits finally reached juries, not jackpot justice, but acknowledgement and remedy. Her closing line echoed Mercer. Rights without remedies are wishes. Remedies without rights are noise. Morris requested coffee. I won't pretend agreement, he said, but I heard you. Mercer appreciated the candor. They debated quietly, history, text, consequences, and parted civilly. On the steps, a tourist asked for a photo with both sides. Mercer demurred. We're one court, arguing about how best to read one constitution. A mural appeared on Maple, a scale held by many hands, officers, judges, kids, elders, beneath the caption, Weight shared, weight fair. At night, someone added 3 small gold dots on the beam's edge. Helena laughed when Mercer noticed. What's that? Ellipses, she said. Work continues. He nodded. Of course it does. A year-end report from Milford PD showed stop disparities narrowing, complaint resolutions accelerating, and a new metric, dignity observations, tracking respectful conduct. Critics rolled eyes, residents noticed difference, insurance premiums dipped modestly. The mayor credited boring reforms. Mercer cheered the boredom. Drama had nearly broken a town. Quiet competence felt revolutionary. On a humid evening, Mercer visited the courthouse bench where his father once taught survival. He traced initials carved decades ago and whispered thanks. A patrol car rolled by. The officer nodded, kept moving. The unremarkable moment felt like a blessing. Public power passing peacefully, unseduced by spectacle, uninterested in domination. At home, Mercer filed a slim memoir. Less confession than field notes, what doctrine misses, how narrative bends truth, where courage hides in procedure. He dedicated it to witnesses with phones, officers with spines, clerks with ethics, and daughters who dragged tired fathers back toward stubborn light when shadows lengthen. Helena walked the center halls alone, listening to muffled practice, commands repeated until gentled, scenarios rerun until reflex bent toward restraint. She texted Jessica, "We built something real." Jessica replied with a photo, a committee hearing where Daniels framed debate, not derailed it. "So did you," the message read. Together, Mercer reread letters from strangers, truckers, teachers, cadets, grandmothers, some grateful, some furious, most complicated. He answered as many as he could, signing with a simple line, "The Constitution lives best when we argue faithfully about it." He meant it, argument as civic oxygen, discipline as duty, remedy as respect made tangible. One afternoon, Pierce escorted Martinez into the square where her video once shocked the country. A brass plaque honored her courage. She brushed tears and laughed. "I was just trying to hold my phone steady." "You did," Pierce said. Nearby, a teenager practiced saying, "Officer, my hands are visible," and everyone wished he never needed it. At the court, oral arguments in a new case probed school searches. Mercer asked fewer, deeper questions. He watched counsel's shoulders, heard the pause before concession, noted how facts softened in hypotheticals. He wrote a narrow concurrence later, praising humility as a judicial virtue, curiosity disciplined by precedent, tempered by consequence. In Milford, the center hosted a joint drill. Residents role-played traffic stops. Officers role-played anxious parents. Everyone laughed, then got quiet. A veteran admitted, I forget what adrenaline does to memory. A mother answered, I forget what fear does to judgment. They tried again, slower, kinder, more attentive to each other's tremors. Mercer returned to Maple alone at dusk. He watched porch lights wink on, heard screen doors sigh, felt the town breathe. The headline days had passed. The work days remained. He whispered to the air, to whoever needed it, keep choosing restraint, keep choosing remedy, keep choosing each other, then walked home. His story doesn't pretend bias vanished. It argues we can out-organize it, procedurally, culturally, humanly. It insists on remedies that bite and training that builds muscle memory around dignity. It trusts people willing to change and pressures those who won't. It knows backlash comes and still chooses the long, necessary haul. If you've seen looks outweigh credentials, say so. If you've watched a badge used as shield rather than responsibility, tell it. If Daniel's opened a door in your town, push through. If you think privilege means never learning, reconsider. Sometimes the bravest learning comes when lifelines are briefly, purposefully set aside. Comment with your view of race, power, and justice after Milford. Should leaders with lived experience shape doctrine? Can policing thrive under accountability? Like if you want institutions that learn, subscribe for more work on how change actually happens. Piecemeal, argued, budgeted, trained. Share with someone who doubts careful, stubborn progress. Remember, progress isn't tidy. It arrives argument by argument, policy by policy, practice by practice. It requires admitting harm without drowning in shame, rewarding courage without courting sanctimony, and building structures that outlast any one name. The aim is simple, vast, doable. Equal protection is habit, not hope, everywhere the law reaches. Thanks for staying through difficulty. If this made you reconsider something, even a little, carry that forward. Talk across lines. Film when necessary. Test policies with real lives in mind. Demand transparency without theatrics. Expect dignity as standard. The arc doesn't bend itself. Hands do, laws do. People practicing together make it so. Under a soft night sky above Milford, cicadas thrummed like quiet applause. The town that once taught survival now practiced repair. Mercer stood beside Helena and Jessica, shoulders touching. Work tomorrow? Helena asked. Every day, he smiled. They turned toward the dark street, walking steady, not finished, not defeated, exactly where duty lives. Lesson 1. What titles can't protect. When Chief Rourke pinned 74-year-old Justice Franklin Mercer against his own Mercedes, many of us saw a truth we've lived long enough to recognize. Rank, ribbons, even Supreme Court robes can't always shield a Black American from suspicion. Dignity must be defended each ordinary mile. Lesson 2. Courage that builds community. Milford's reckoning proved change needs both brave witnesses and steady institutions. A bystander's full video, a young officer's conscience, and a daughter lawyer's grit turned one routine stop into reform with teeth, care checks, transparent stop data, real consequences. Accountability isn't anti-police, it's how good policing survives. Friends, after Justice Mercer's ordeal and Milford's hard lessons, what do you believe actually keeps Americans safe and free? Thicker shields for authority, stronger remedies for abuse, or a careful balance that protects good faith officers while ending impunity for reckless harm? Have you, across your decades, seen respect given or stripped away because of age, race, or the car someone drives? If you were on that roadside, what outcome would honor both dignity and due process? Share your story below. Tap like if equal protection matters every day, not just in headlines, and subscribe so you won't miss the next chapter of this ongoing investigation.